Mr. Molina, it's your motion.
Yes, Your Honor.
And for the record, I call the court to order. This is a pretrial hearing, State of Texas versus Gilbert Molina, case number 504-867, a motion to dismiss for violation of right to speedy trial. As Mr. Molina just mentioned, the alleged offense was from July the 9th of 2015, which means this matter has been pending 5 years?
5 years, Judge.
All right, you may proceed, sir.
Judge, this case was, the alleged incident was July 9th, 2015. Shortly thereafter, on August 20th, 2015, the information was filed. There was a warrant issued same day. That warrant, and we submit that warrant was never served until the defendant voluntarily went to do a records check at the police department and was arrested there for it. We are asserting our right that this case should have been more diligently pursued, and nothing has happened since that date. He has been a homeowner for 50 years there, and that was the site of the incident where he lives. No one has attempted to serve a warrant at his house. He's applied for a license and at the Department of Public Safety and has not been arrested there. Has had a citation, a traffic citation since then, wasn't arrested. And again, he was only arrested because of him going over to the police station to check on his record. So we ask that this information be set aside and the case dismissed.
All right, I hear that, but I think you know there's certain hoops you're going to have to jump through.
All right, Judge. Well, we wanted to see what the district attorney's office has done to pursue this case, Judge. We're asserting our right.
I understand that, but you're not just asking me for a speedy trial. You're asking me to dismiss, and for me to do that, there's certain hoops you have to jump through.
Right, Judge. The speedy trial test has a 4-pronged test, Judge.
There you go. Now we're talking.
And one is the length of the delay. In this case, it's been 5 years. Now, the second part is the reason, and we haven't heard from the district attorney's side what the reason is. Now, number 3, we have asserted our right, Judge. We have filed a motion. And of course, the 4th prong is prejudice to the defendant. Now, Mr. Castillo, 5 years, this incident happened 5 years. Our opportunity to get witnesses for this case is gone. Memories have faded. People have moved in and out of where. The unique thing about this case, Judge, is that it happened at his home. So, I mean, there's no way that they couldn't have gone over to find him over there. And so we didn't know anything about the case until now. And we could have gone out there and asked neighbors what's going on. People have moved in and out, and memories have faded. And I don't know if we can help him out and mount a defense for him this late a date and time, Judge. So okay. I think we fulfilled the 4-prong test.
Judge, excuse me, Judge.
Yes.
Do you want me to go ahead and put Andrew's witnesses in a waiting room? Because they're listening.
It's not up to me.
Okay.
All right, Mr. Molina, I'm hearing what you're saying, And that's just it. I'm hearing. There's no evidence at this point. You're gonna have to give me evidence, sir. You're making argument, and that's fine, but that does not constitute evidence at this point. You need to give me evidence.
Okay, Judge, may I put on the defendant then?
Absolutely.
Okay.
Mr. Castillo,
Yes, Your Honor.
please raise your right hand. Do you solemnly swear that in this proceeding, any answers or responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Mr. Molina, you may proceed.
Thank you, Your Honor. Mr. Castillo, are you the defendant that has been charged with the crime of assault?
Yes.
And when did this incident happen, more or less?
Back, all I know is 2015.
Would July 9th be about the time that it happened?
Yes.
Okay, and since that time, have you ever had any officer come by your home to try to serve a warrant because of this incident?
No.
And have you been or had occasion to run into a police officer? In other words, did you receive any citations during this time?
I have.
And were you made aware of a warrant for your arrest?
No, I wasn't.
And have you renewed your license since the date of the incident?
Yes.
And was there any problem there getting your license?
No.
Were you informed of any warrants?
No.
Okay, and where do you live, Mr. Castillo?
447 East French.
And was that the place of the incident that is the information that has been filed against you?
Yes.
And have you moved since that time?
No.
And you've consistently lived there since the date of the incident, July 9th, 2015 till today?
Yes.
And how is it that you were arrested for this case?
Because I went down to the police department to question about identity theft on my part.
And at that time, they told you there was a warrant for you?
Yes.
And that was the first time you found out about that?
Yes. So I just turned myself in.
And Mr. Castillo, have you had an occasion to, in other words, find witnesses for your case?
No.
Yeah, I mean, you haven't tried because you didn't know about any cases pending, right?
No, I didn't know.
So would it be difficult for you to find, witnesses? For this
Yes.
case? Okay. Judge, I pass the witness.
Mr. Edelman,
On July 9th of 2015, you were treated into your house after your altercation with Ms. Leak. Isn't that correct?
Yes.
Is there anybody in the house with you?
No.
So there were no witnesses in the house who would be able to assist you in your defense. Isn't that correct?
That's true.
You had neighbors at the time. Do you know who they were?
No, because I really didn't talk to any of my neighbors there. And it was late at night that night.
So do you know if any of your neighbors would be able to assist you in your defense?
No, because if they did, I'm sure they would have came and talked to me.
That
Nobody
wasn't
ever
what I
talked-
asked. Do you know if any of your neighbors would have been able to assist you in your defense?
No.
Do you know if any of your neighbors have moved?
I'm not sure because yeah.
So essentially what you're saying is that there's no one in your house who would be able to assist you, and you don't know of any witnesses who would have been able to have assisted you. Isn't that correct?
That's correct.
That's the witness.
Mr. Molina,
Yes, Mr. Castillo, you haven't asked your neighbors whether they witnessed the incident because you weren't aware of any charges pending against you, have you?
That's true. I haven't.
And if you had known there was charges pending, would you ask your neighbors if they witnessed that incident?
Yes.
Okay. Pass the witness, Judge.
Mr. Castillo, you were arrested for this offense on March 4th of 2020. Is that correct?
Yes.
So that was approximately 4 months ago now. Isn't that correct?
Yes.
And in the 4 months that you've been aware of this pending charge, have you made any effort to contact your neighbors in order to ask them if they have any memory or recollection of this event?
No.
Nothing further, Your Honor.
Mr. Molina.
Yes, Mr. Castillo, right now, as a result of this pandemic we're having, do you get out in public?
Oh, no. I stay home.
And so you really haven't had an occasion to go ask people about your case?
No.
All right. And I pass the witness, Judge.
A few further questions, Your Honor.
Yes, sir.
Have you left any letters on your neighbor's mailbox or at their doorstep?
No.
Have you tried calling them?
No, because I don't have any of their phone numbers.
Have you tried getting any of their phone numbers through any medium or any method?
No.
Have you tried contacting them in any way?
No.
Pass the witness. Your Honor.
Judge, I don't have any other questions.
All right. Next witness, Mr. Castillo.
Mr. Molina, yeah. No, Judge, I don't have any other witnesses, Judge.
All righty. Okay, Mr. Edelman.
State would like to call Captain Roach of the Bexar County Sheriff's Office.
Spell the last name.
R-O-A-C-H, Your Honor.
Captain Roach, please raise your right hand. You solemnly swear that in this proceeding, the information or responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Mr. Edelman, your witness.
Captain, would you please state your full name and rank for the record, please?
Thomas Franklin Roach, Jr., Captain, Bexar County Sheriff's Office.
How long have you been an employee of the Bexar County Sheriff's Office?
Since August of 1985.
That is a long time.
Yes, sir.
What is your current assignment?
My current assignment is Captain of Judicial Services, which has oversight, Fugitive Apprehension Unit, Mental Health Unit, and our Civil Section.
And how long have you been in that position?
A little over a year, maybe a year and a half, close to that.
And the Judicial Services section, does that include the Criminal Warrant section?
Yes, sir. Also known as a Fugitive Apprehension Unit also.
Which is the preferred terminology?
Depends on who you ask. Either one. Criminal warrants is fine. Fugitive apprehension is fine too. So
Is it all right if I stick with criminal warrants then?
yes, sir. Yes, sir.
Now, was there a warrant issued for the arrest of Gilbert Castillo?
There was, based on the computer records, there was a warrant issued.
When was that warrant transmitted to the criminal warrant section?
The issue date, let me see here. The offense date was July 9th, 2015. The receipt date was November 18th, 2015.
And at that point, what did the criminal warrant section do with that warrant?
Due to the fact that it was beyond my time when I got here, the standard thing was it'd be entered into the system, NCIC, TCIC, and whether no one's assigned to it per se. It's in the system and it's just held in that queue until it's either worked or someone comes across them.
Now, I know that this warrant predates your assignment to the criminal warrant section, but do you still know why no one is assigned to work a particular warrant?
Well, you can go back to something as simple as manpower. You know, we currently have over 17,000 misdemeanor warrants, and I have 10 officers that are assigned to criminal warrants to actively seek out people in regards to that. So 17,000 misdemeanor warrants, 7,000 felony warrants. We prioritize. In the past, I know we use a postcard mailer to send out to the addresses for defendants to see if they'll turn themselves in. So how many times that was done over the past 5 years prior to his arrest on this offense, I couldn't tell you, but I know we've done that in the past.
Now, are there any notes that are kept by the criminal warrants section in regards to particular warrants?
We do whenever on the computer system on our local system, we update what we call an AS page. So if someone did make the attempt to go by the address or come across them at that location that's listed on the warrant, then they would put that on there. The address that he has listed is 6631 Lakeview Drive, number 9. That's the address that's listed on the warrant, but there's no indication that anyone went by there at that location.
Is there any indication that anybody searched to see if that address was up to date and current as of 2015?
I would be unaware that if they did.
Now, the defendant during his testimony stated that he had applied for a license and not been apprehended. Is that typical in your experience?
I don't think it's typical. I know we do pick what we call pickups. We do pickups from other areas. Now, whether DPS had participated at that time with notifying us if they have a wanted person at their driver's license office, I couldn't tell you.
And if a patrolman in some jurisdiction had detained Mr. Castillo and run his name as it appears on the warrant, is there any reason that you can think of that Mr. Castillo would not have been taken into custody because of that warrant?
I can't foresee any reason other than whether the officer actually ran him or checked him, or if he provided the correct information and he was able to verify it.
But you would need to know more about that particular stop in order to be able to comment intelligently on it.
Of course, yes.
Now, did the criminal warrant section refuse to execute the warrant on Mr. Castillo in order to secure some benefit to the state?
No.
In your opinion, is this failure to execute this warrant in a timely fashion a matter of negligence on the part of the state?
No.
Why do you believe that?
It's just as far as logistics go, as far as the quantity of warrants in Bexar County and across the state is probably more than most agencies can keep up with.
Pass the witness, Your Honor.
Mr. Molina.
Yes, Officer Roach, you were asked about notes made on that particular file. Now, did you say there was no notes on that file?
The only notes that are added to the file are dated 3/3 of 20, where it says WP, which for his wanted person, arrested at 200 North Comal at 12:30 hours.
Okay. To your knowledge and your review of this file, was that warrant ever attempted to be issued at the residence of this defendant?
I don't know I believe I heard that his residence was listed as French, on French.
Yes.
Did I hear that earlier?
Yes. Well, that was the place of the incident and his residence.
Okay, I have no knowledge of that would be his residence. There is on the that's a comment that's added. It says 447 East French 78212. That's on a comment section. But that's different from where the defendant's name and address is listed at the top where it says Lakeview Drive, 6631 Lakeview Drive, number 9. So I don't know if that was another residence that he had or prior.
So you don't know how that Lakeview address was supplied. Is that correct?
I don't know how. I mean, I can offer several reasons as to how it was, but I don't know how it's on there on the warrant.
Okay, but you haven't read over any kind of police reports regarding this incident, have you?
No.
Okay, so normally if a warrant is issued and it's supplied to your office, how is it executed? In other words, where do you go look for a defendant?
Well, I'd say over my 35 years, unfortunately, not all records are updated the way they should be. So if I understood correctly, he got arrested that night for the offense. My guess is when he got arrested, either identification said that his current address was on Lakeview Drive, or someone had told the officer that this is where he's residing. That would be.
So you're just assuming or guessing that's what happened? You don't have any personal information about that?
No, I have no personal information about it, but that would be the only rational way to understand where the address came from.
Okay, well, if I told you he was not arrested that night, but the police reports indicate that he lived at that address, so you don't have any idea how they got a Lakeview address on that?
I do not, no.
And do you show that a warrant was attempted to be issued at the Lakeview address? Was that done over there?
There's no indication that any officer worked on the warrant.
Okay.
Because there are no notes on our system.
Okay, so you don't know if they ever attempted to serve that warrant at that Lakeview address, right? Okay, and sir, do you often get calls from the district attorney's office concerning the execution of a warrant on a pending case?
We do get calls from the district attorney's office, maybe not the attorneys, maybe investigators or other agencies in regards to executions of warrants.
And you think the purpose for that is to make sure that this case is carried out in a prompt fashion?
It depends on the severity of the offense. I would think. It's not to say that all offenses aren't important or aren't severe. There is a difference between felonies and misdemeanors.
Okay, so, but in this case, the district attorney's office never checked, or you don't have any notes that the district attorney's office checked with you regarding that warrant?
I have never been contacted in regards to this warrant, and there's no notes that are indicated that anyone called in regards to the warrant. Now, whether somebody looked it up at any given time, I don't know. I couldn't tell you that. There is no information.
Okay, thank you, officer. Pass the witness.
No further questions for Captain Roach.
The captain be excused.
Yes, Captain may be excused.
Captain, if you choose, you may leave the meeting. We appreciate your participation. Thank you, sir.
Thank you, sir. Nice to see you again.
Same here. All right. Next witness, Mr. Edelman.
State calls Jessica Leak. Good morning, Ms. Leak.
Morning.
Would you please state and spell your name for the record, please?
Jessica Leak, Jessica, last name Leak, Leak.
And would you please tell the court in what city and state you currently reside?
I currently live in Gunnison, Colorado.
Now, this offense allegedly occurred on July 9th of 2015.
I think she needs to be sworn.
Your Honor?
All right.
would you please swear the witness in?
Yes. Ms. Lee. Is that how you pronounce it, Lee?
Leak, like a leak in a faucet.
Okay, I'm sorry. And you spelled it
Leak.
H.
Leak.
Okay, I got you.
May I proceed, Your Honor?
No, I haven't sworn her. Ms. Lee, raise your right hand, please. Do you solemnly swear that in this proceeding, the information or responses you provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Do, Your Honor.
Thank you, ma'am. You may put your hand down. Mr. Edelman, you may proceed.
Excellent, Your Honor. So you stated that you currently reside in Gunnison, Colorado.
Correct.
And how long have you lived there?
Since September 9th of 2019.
Now, do you remember the incident that led to this case?
I do.
If this case were to go to trial, would you make yourself available to testify?
I would.
Even if that included physically returning to Bexar County, Texas, in order to testify in person in front of a jury and under oath?
Yes.
And why would you be willing to do that?
Because this incident has haunted me for the past 5 years. And I think justice is warranted here. Nothing was ever concluded. And because of that, I have had zero closure. I was contacted several times by an investigator, and she said that she was going to take this and the witnesses to the DA's office, and we were going to move forward from there. But I hadn't heard anything since then, not until you called me last week.
Nothing further, Your Honor. Pass the witness.
Good morning, Mrs. Leak. You said you contacted the DA's office. When did you do that?
No, an investigator of the case contacted me, saying that she had followed up with my 3 witnesses that were at the scene. And she said she was going to pass this on to the DA, that this needed to go to trial. And that was the last time I heard anything.
Okay, and when was that? Can you tell?
That had to have been July or August of 2015.
And since that time, have you called over to the DA's office to find out about your case? I know it's been a lot of pressure for you and torment or whatever. Have you called down there to find out what's going on with your case?
I did a year ago, because I knew I was leaving the state, but I did not hear back.
So they never called you back,
I never got a call back.
but you did call them.
Yes.
All right, I pass the witness, Judge.
I have no further questions for Ms. Leak, but may we leave her in the proceedings so that she can observe if she wants?
Yes, you may.
Ms. Leak, would you please place your microphone on mute?
Well, hold on a second. Yeah, okay. Ms. Lee, I have a couple of questions. How many people were there on the scene when this event occurred?
There was one with me when it occurred, and then there were 2 that were walking up the sidewalk who stopped Mr. Castillo.
Were they written down by the police as witnesses?
I'm not sure. I don't have that report. I know 2 of the people's names. The third one, I don't recollect her name.
And were they just witnesses, or were they participants, or was there someone with you?
There was someone with me, Peyton Ryder. She was present during the entire incident. And
R-I-D-E-R?
Reiter.
No, spell that again for me.
Sure. I believe it's Reiter. Ter. First name Peyton.
Do you know where she's at?
I do not know where she's at. I know she's a doctor. I think she's back in Texas.
Okay. All right. One totally non-court issue. What kind of temperature did you have yesterday in where you live in?
You mean weather-wise?
Yes.
It was a good 84 degrees. Not 110 or whatever you guys are dealing with.
I think we had about 110 yesterday. All right. I appreciate that. It's not on the case, but I was just a little curious. Let's see. Mr. Edelman, any other witness?
No, Your Honor.
Mr. Castillo, I'm sorry. Yeah, Mr. Molina, anything further?
No, Your Honor.
All right. Mr. Edelman. Mr. Molina, any argument?
Well, I'm going to reassert that we've proven that there's been a lack of due diligence on the part of the district attorney's office. The victim in this case checked on her case and it was assured that something was going to be done. It's been 5 years, Judge. It's going to be very difficult for us to find our witnesses to help my client. There's been great prejudice to him for waiting all this time. Very rarely do you have a incident and a defendant at the same address, Judge. I mean, he wasn't hiding. They're not saying that he was not evading the law. He's always been there, Judge. We don't know these witnesses are going to be found. It sounds like they're just right now trying to make a case 5 years later, Judge. It's presumptive that it's too long of a delay when it's just a year out, Judge, but we're looking at 5 years, Judge. If we find the witnesses, are they going to be able to remember? I know I passed 2 or 3 years and it's pretty foggy for me, Judge. And I believe that there's great prejudice to my client. We've asserted our right. And 5 years is just too long, Judge. And I feel that this case should be dismissed, Judge. I don't think the district attorney has given any reasons for their delay. And it wasn't the victim in this case that she did try to find out about her case and they just didn't do anything to help her out, Judge.
Mr. Edelman, is that it? Excuse me, Mr. Molina, is that
sorry,
it?
Judge. Yes, that's it, Judge.
All right, Mr. Edelman.
Your Honor, as the court is well aware, an 8-month delay is considered presumptively prejudicial for purposes of speedy trial right analysis. However, once that prejudicial delay time period has lapsed, the court then needs to engage in an analysis of the Barker-Wingo factors. Now, one of the important aspects of Barker-Wingo is that no single factor by itself is either necessary or sufficient to finding a deprivation of the right of trial. The factors are related with one another and they must be considered together with other such circumstances as may be relevant. Now, the state has 2 responsibilities in speedy trial argument, explaining the length of delay and explaining the reason for the delay. The length of delay is already well established. The reason for the delay, the court heard the testimony of Captain Roach, who stated that in his experience, misdemeanor cases typically are not actively pursued simply because of the relative lack of manpower. And while this is unfortunate, under speedy trial analysis, intentional or deliberate prosecutorial delays are weighed more heavily against the state, while neutral reasons such as negligence or overcrowded courts weigh less heavily. Since Captain Roach testified that the failure to execute the warrant in this case was not sought in order to provide the state with some sort of advantage in terms of prosecution of the case, it seems evident to me, at least, that the reason for this delay is because of negligence and a lack of resources, which, while still weighing against the state, weighs considerably less heavily against the state than a more intentional or deliberate reason might. Now, the state has the burden of justifying the length and the reason for the delay, but the defendant has the obligation of demonstrating that he has actually asserted his right to speedy trial in a timely fashion, and that he has suffered some sort of prejudice as a result. Now, because of the procedural history of this case, that the defendant was not arrested at the time that the incident is alleged to have occurred, that a case was filed at large, but the defendant was never made aware of the fact of that pending case, it is a bit absurd for the state to claim that the defendant failed to assert rights to speedy trial for a case that he was not even aware existed, at least technically speaking, in terms of speedy trial analysis, because the right attaches when a defendant is formally accused. But in terms of analysis of this particular factor, one thing that the court should take into consideration is whether the defendant actually had notice of a pending case. And in this instance, there seems to be no indication that Mr. Castillo had notice of the pending case. So that, I think, weighs neither for nor against Mr. Castillo. However, the last factor, prejudice to the defendant resulting from the delay, I think weighs against Mr. Castillo for the following reasons. The prejudice to the defendant resulting from the delay is analyzed using three interests: preventing oppressive pretrial incarceration, first; second, minimizing the defendant's anxiety and concern; and third, limiting the possibility that the defendant's defense will be impaired. And I want to be absolutely clear. It is the defendant's defense that is protected from impairment, not the case at large. Now, in terms of interest one, preventing oppressive pretrial incarceration, Mr. Castillo has presented no evidence that he suffered any oppressive pretrial incarceration. Mr. Castillo did not testify as to the length of time that he actually spent confined as a result of having his warrant found and being taken into custody. However, I can state that from the papers of the court, Mr. Castillo was taken into custody on March 3rd and released on March 4th. So that is 1 day of incarceration weighing on Mr. Castillo's nerves. In terms of interest two, minimizing the defendant's anxiety and concern. Well, if Mr. Castillo did not have notice of a case for purposes of asserting his right to speedy trial, he also had no notice of his case for purpose of establishing an impairment of prejudice because of excessive anxiety and concern for his case. If he wasn't aware of the case to begin with, then logically, it is impossible for him to state that he suffered any anxiety and concern as a result of it. Finally, the third interest, limiting the possibility that the defendant's defense will be impaired. Mr. Castillo has not actually presented any evidence that he is now unable to present witnesses who would be able to testify in his defense. There was nobody in the home with him that he would be able to now call as a witness who is now unavailable. There was nobody in the home with him at all who was a witness to this case, according to Mr. Castillo. His neighbors may have seen something, but the defense has presented no evidence that any of his neighbors actually did. The defense has presented no evidence that they've made any attempt at all in the intervening 4 months to make any contact with them in any way to determine, one, whether they actually witnessed any of the events that gave rise to this case, or two, if they had, whether they would be available to testify. Similarly, the defense has not presented any evidence to the court that they have attempted to contact any of the witnesses who are listed in any of the reports. And so the defense has not presented any evidence that any of those witnesses, either one, would be able to give testimony that would be helpful to the defendant, or two, that they are actually unavailable to testify if they had such testimony to offer. So in the analysis of the speedy trial factors, the two factors that the defense is responsible for presenting evidence to the court of having been violated, the assertion of the right and the prejudice to the defendant, there's been no evidence either for or against the assertion of the right, but there's also been no evidence in terms of prejudice to the defendant. And that weighs extremely heavily against the defense, especially considered that while this was a 5-month delay in executing the warrant, Mr. Molina has had 4 months in order to begin conducting investigation and has not presented any evidence whatsoever as a result of that time in which to conduct such an investigation. So for the reasons presented to the court, the balancing of the factors should not weigh in a finding of the defendant's, of a violation of the defendant's right of speedy trial. The request for dismissal should be denied and the case should be placed on the trial docket at the earliest possible opportunity. Thank you.
Mr. Edelman, a question. Doesn't the case law say that after an 8-month delay that is not adequately explained or an adequate excuse offered by way of evidence, that it is presumed to be prejudicial?
You are partially correct, Your Honor. The case law does state that. However, what the case law further states is that when the presumptively prejudicial delay threshold has been met, the court then needs to make an analysis of the Barker v. Wingo factors. And the court needs to make that interrelated analysis of all of the factors with no single factor being necessary or sufficient to finding a deprivation of the right to speedy trial. So there may be a presumptively prejudicial finding for purposes of then deciding that the Barker v. Wingo factors need to be analyzed, but the Barker v. Wingo factors still need to be analyzed independently of that presumptive finding, and the defense still needs to present some evidence of prejudice if the court will make a finding of prejudice, which the defense is still required to do. Your Honor.
Yes. All right. Anything else from either side?
Judge,
No.
because of the crisis that we're under, Judge, it's kind of hard to investigate this case that's 5 years old, Judge. It's not 5 months like he stated, it's 5 years, Judge. That, I mean, it's already built in that it's going to be very prejudicial to my client that this case proceed.
All right.
I have plenty more that I would like to say, Your Honor. However, the order of argument entitles the defense to open and close on its motion.
All right, well, I'm gonna take it under advisement. You'll have a ruling by Friday. Kayleen, if you'll remind me Friday morning, I'll go ahead and give them a ruling. All right,
Yes,
all
sir.
right. Anything else?
That'll be all, Judge.
Okay, guys. Thank you. Ms. Leak, thank you. All of you be blessed, be well, and be safe. Ms. Leak, enjoy your not so hot weather, but although in Colorado at 81 degrees is a little warmer than it used to be. Years ago, it would be in the 60s, 70s at the most. Anyway, thank you all. Appreciate your participation. Kayleen, thank you for your work. Mr. Edelman, Mr. Molina,
Thank you, Judge.
and
Thank you.
Patty and Ms. Sherrera. Take care.
Thank
All
you.
right, Judge.
Be safe, Your Honor.
You too.